Hello, I'm Adam Kielich, the principal attorney at the Kielich Law Firm in Bedford, Texas, where I help clients with their employment law, consumer law, and family law needs. Today's video is going to be a little different from the normal videos that I do. Normally, my videos are focused towards individuals who may have a claim against an individual or an employer or some company that they've done business with, and helping them understand the law surrounding those potential claims and help them understand if they have a potential claim and what that claim would mean. Today's video instead is going to be targeted towards employers, specifically within the craft beer industry, and really very specifically towards breweries. I do a little bit of work within the craft beer industry, working employer side, advising companies, and to some extent as well, advising employees within that industry. So I thought I would assemble some of the topics that I normally address with craft breweries into a single video, with a lot of people transitioning from home brewing or out of working as assistant brewers into owning breweries or operating breweries at a higher level. There's a lot of opportunities for legal issues involving employment issues to become real serious problems for those businesses. A lot of that has to do with the fact that a brewery by itself is not really one business as much as it is often multiple businesses that have kind of come together into a single operation. On one hand, it may be a manufacturing facility, and we tend to think about breweries, at least from a consumer side, of being this place that serves beer, and they make the beer in the back, and we go kind of run around, they give us a tour, and it's not that big of a deal. But they're actually very serious manufacturing facilities with very dangerous equipment and very dangerous chemicals being employed. It may also be an operating bar. If you have a tap room on site that's serving beer, you may have all of the same issues that any other bar or restaurant may have with your service and your servers. It's also often a normal office operation with marketing wings and management and various other departments. And so all of that coming together can create a number of serious issues that arise within the employment context between those various employees and the craft brewery. So there's 7 issues that I would identify as being the most prominent and the most important ones to be aware of for a craft brewery. So we'll just run through all of those and talk about them a little bit. First one is OSHA compliance. As I said, a brewery is a manufacturing facility, and it's a manufacturing facility first and foremost. Even a brew pub that's brewing on a small system in a back spare kitchen area is still a manufacturing facility. And there's, as I said, dangerous equipment, dangerous chemicals, and of course lots of hot liquids moving around that can cause some pretty serious burns as well. So it's important that these facilities have strict compliance with OSHA requirements. If we're a brewery, there are safety procedures that have to be put in place, and often very specific requirements about availability and access to those procedures. There are building requirements that fall within OSHA compliance as far as what the building has to have within it and the design of the building, and of course safety equipment and the use of that safety equipment also falls within OSHA's purview. To run into problems with OSHA can be pretty serious. OSHA, to my knowledge, has not targeted breweries as a very serious issue for investigation or regulation, but that doesn't mean that won't change in the future or that OSHA is completely oblivious to what goes on in breweries. And so it is important that breweries have all of the standard operating procedures necessary, not just to make beer, but also for safety procedures to make sure that that beer is being made safely, not just for the employees, but for the customers as well, and to make sure that those procedures, and especially that safety equipment, is being used and followed as appropriate. Most of the breweries I've been in, I think, are pretty good about making those procedures well known amongst the employees, and the employees are using the right kind of safety equipment. But the smaller a brewery is, the less experienced the owners may be with those OSHA requirements. Sometimes managing those procedures and the use of safety equipment is not quite at the level that it should be. To have somebody be injured because OSHA requirements are not met could become a serious problem, both for an employee who's injured as well as a consumer or a customer that's injured by some sort of failure of a safety procedure. Hopefully your brewery is well insured against these kind of injuries, but the reality is, like with anything, money might be the only way that a court can compensate somebody who's been injured, but it doesn't change the fact that they are injured and that person's life has non-monetary harm caused to it by the injuries, which sometimes can be and have been fatal within breweries. So make sure that you're following the right safety procedures as far as what OSHA requires, as far as what your equipment manufacturers require, as far as what your supplier manufacturers require. Make sure that you're using the right kind of equipment and the right kind of kegs and bottles and all that good stuff. Number 2, on the fairly same issue, is workers' compensation. And workers' compensation is a no-fault. Let's call it a no-fault system. So under workers' comp laws, if an employee is injured within the brewery performing his or her job, without determining whether the company or the employer was actually liable for the injury, workers' comp steps in and pays for the injury to the employee. So the issues here really overlap with the OSHA compliance, and that's making sure that employees are following safety procedures, that there are safety procedures, and that safety equipment is available and in use on a regular basis. Oftentimes, employers carry workers' comp insurance, and the insurance company will step in and make the payments on a workers' comp claim. But you don't want to have those claims in the first place, and even if the insurance company is paying them out, you still run the risk that you're going to be out an employee who's off getting treatment or recovering or whatever. And there's also the possibility of retaliation claims if an employee files for workers' comp, whether or not they're actually awarded benefits. If an employer retaliates against that employee for filing the claim, that's an independent claim against the employer. And while workers' comp laws tend to limit the amount of money an employer has to pay on an injury, those limits don't exist on a retaliation claim. When a retaliation claim hits, the employee has a lot of possible opportunities to recover against the employer, including payment of attorney fees. And anytime you have payment of attorney fees, you have a high probability that some plaintiff's attorney, like myself, is going to be interested in that case and may come calling on that retaliation claim. So as a whole, both issues, make sure you've got those procedures and the safety equipment in place and that you're managing their use. So number 3, we'll move away from safety issues and talk about volunteer work. At some breweries, they like to go out and ask people for volunteer work, basically to come in and work in the brewery for free. And with the number of people that want to work in the brewing industry, there's a lot of people contacting breweries begging for free work just to get their foot in the door. Now, this sounds like it shouldn't be a problem. People want to work for free. That's their prerogative right. But the Fair Labor Standard Act Act and a number of state payroll laws prohibit a lot of this kind of volunteer work. For the most part, the work that I see breweries inviting that's volunteer work is actually illegal under these laws. And the reason why is the Fair Labor Standard Act and the state analog laws take the position that if you're taking work for free from somebody, you may well be doing that under coercion. It may not actually be their choice. And even if it is their choice, you're avoiding paying somebody an actual wage by taking free labor from somebody else in a way that you're actually benefiting from their work. So the laws look at not necessarily what the employee is doing, but what the employer is benefiting without making payment to the employee for those services. But that's not to say that all non-paid work is necessarily unlawful. There can be situations where somebody actually comes and volunteers, and because of the structure of the agreement or the work that's performed, it is legitimately non-paid experience for that person. The easy test here is where somebody is looking for an internship, where they're a college student or they're in some sort of technical school program, and as part of that program, they're getting academic credit for the work that they're doing at the brewery. This can be acceptable non-paid work, although you have to be careful about the kind of work that's being performed to make sure that it's actually to the benefit of the intern rather than just merely the employer not paying somebody for work and scooping them up because they happen to have academic credit attached to it. Similarly, there could be people who come in and just kind of want to hang out and watch the brewing process, and maybe you let them shovel the mash tun a little bit or push a few buttons. Sometimes that can be fine that they're quote-unquote volunteering when they're not really working at all. But there's not a bright line between when somebody moves from a lawful form of unpaid labor to an unlawful form of unpaid labor. And the tests for this kind of work are murky. They're not specific at all. They look at a number of different factors. And so at this point, I haven't seen a lot of attacks on breweries or a lot of claims brought against breweries for not paying for supposed volunteer work or for supposed internships, but it may only be a matter of time. These claims are becoming across the board, across the job market, more popular as more and more businesses are chasing after free labor under the guise of volunteer work or internships. The easy test, I would say here, is if you're having people come in and work for free on your bottling line or sweeping or some other nonsense where this is obviously work that is like true work that you should have hired somebody to do, there's a really good chance that it's illegal for you not to pay for that work. And people may feel like they can run the risk that nobody is going to catch on if the supposed volunteers are glad to do that work and they're happy about it. Maybe they're not going to complain, but things start rolling. One person says something else, and next thing you know, there may be a DOL auditor or your state labor agency auditors or investigators showing up. The Department of Labor has made it known fairly well that over the past several years and continuing into the future, this unpaid labor issue is going to be a prominent focus. And so they may not have caught word how rampant it is within the brewing industry, but it's not going to take much for them to find that out. And they can go back in time and see what kind of unpaid labor you were absorbing. And even if the supposed volunteers don't want to get paid for the time, that may not change the fact that the DOL is going to come in and audit your work, which can be very expensive, and that they may assess fines, and that can be fairly expensive itself. A DOL audit can run thousands of dollars in time for you and cost of bringing in an accountant or a payroll expert to assemble your records into whatever format the DOL investigator wants, which is hardly worth the benefit of having a few hours of free bottling help from people. So be very cautious about the kind of unpaid labor you're receiving as a brewery. It's really an issue where talking to your legal counsel or obtaining employer-side employment counsel would be a really good idea. Continuing on wage issues, but on a different front, let's talk about tip issues that go on within your tap room. So it's fairly common for the employees that work in the tap room, the bartenders, the servers, to work on tips. And if they work on tips, you probably take a tip credit and only pay them $2.13 an hour, or if you're in a different state from Texas, your state may require you pay a higher amount, even with the tip credit on the pool. These are fine as long as you're paying whatever the law says. Where you run into problems is a lot of times management or even the owner will come in and work in the tap room alongside the employees. And then there's a tip pool put together where all the tips go into the jar together. And then the manager, the owner, whoever's working in there takes part of the tip pool. Now, on face value, this may seem perfectly normal. You're working as part of the staff that is tipped, take a part of the tip pool. The problem is that the Department of Labor and most of the courts take the position that supervisors and owners of the business are not entitled to take part within a tip pool, that the money that goes into the tips are the property of the employees. And by employees, I mean non-management, non-owner employees. And that even though some of that tip pool may have been earned by managers or owners, it's commingled with money that was earned by the normal working employees. And so to take part of that pool, you're taking part of that money away from the employees as well. And that becomes a violation of the Fair Labor Standards Act, as well as most state laws, because tip pools can only be shared amongst the employees and not amongst management or owners. Like the volunteer work, I know this is a fairly common practice that occurs across the industry, but nevertheless does not make it legal just because it occurs. The tip issues as well is another hot issue with the Department of Labor that they're chasing after. So you may have gotten away with it for now, but it may only be a matter of time before the DOL starts looking at the brewing industry and how these tip issues are being affected. Now, it's worth pointing out that within the federal Ninth Circuit, which are the West Coast states, the Ninth Circuit has said that if no tip credit is taken, that supervisors can take part within that tip pool. But that seems to be the only place where that idea has caught on yet. And so that may be an exception there. And again, I would say if you've got questions about setting up a tip pool or concerns about setting up a tip pool and who can participate in it, you definitely need to talk to counsel that is familiar with these tip pool the laws and the regulations around tip pools. There is a ton of terrible and outright wrong information on the internet about this. I assure you, it is categorically wrong, and people following it are setting themselves up for some real problems. And all the legal issues aside, the reality is servers and bartenders know when people higher up the chain are taking part of the tip pool. They don't like it. It's a reason why a lot of employees leave restaurants and bars, because they know that they're not being paid what they're supposed to be, or that they could go find somewhere else where management is not dipping into the pool. And as a result, you may be undercutting the quality of employees you're getting in your tap room, which may be a huge source of income for your brewery. So really be mindful of the way in which you're dealing with the tip pool. And in general, make sure your employees are being paid what they're supposed to. So let's move away from wage issues and talk about alcohol liability. Here's our number 5 issue. Of course, as a brewery that sells and likely serves alcohol, you've definitely got to be concerned about your liability with patrons drinking and then driving away and the injuries that they may cause. But you've also got to think about how your employees are drinking and what happens when they are either on the job drinking or are drinking at your premises and then leaving and getting in a car and driving themselves. Oftentimes, jobs within breweries involve some kind of drinking, sensory analysis, testing new beers, tasting for blending, all these kinds of things that involves imbibing alcohol. And it's a pretty common practice as well, of course, to do the shift beer at the end of the shift. Some breweries let people sit in the tap room, or they have private employee tap rooms where people can drink either for free or at a discount at some point around their shift. With all these people drinking, you've got to be mindful, certainly if they're operating equipment, if they're driving forklifts or working with chemicals that could be dangerous, if it feeds into the final product or if it spills, to make sure that people are not taking these potentially dangerous job responsibilities into their own hands while they're consuming alcohol or after having consumed enough alcohol that they may be impaired. As well, of course, you've got to make sure that if people are drinking away from work as part of the job, like salespeople who go out and drink with bar staff to introduce them to the product, or people who are drinking at the end of their shift and then leaving, how they're driving may be impaired by the alcohol, and what kind of steps you're taking to control the amount of alcohol that they're drinking. So the easy answer here is to set policies as far as how people drink before performing certain job duties, particularly with those dangerous chemicals or heavy equipment. Set policies as far as what kind of drinking can occur after work or on the job site, and make sure that you're setting some sort of clear rule as far as that drinking goes, particularly with that after work drinking where people might have a beer and then immediately go drive off. That one beer may or may not be enough to make their driving impaired, but if they're having more than one beer, certainly that becomes a more serious concern. And you have to make sure that whatever these rules are that you put in place, that you're enforcing the rules. Because, of course, people can be seriously injured both inside and outside the brewery by this conduct. And from a practical standpoint as well, if you've got employees who are intoxicated in your tap room, like them drinking your beer might be a good sign to customers that the people that work there believe in the product. But if they're getting trashed in the tap room, they may be acting in a way that's offensive to customers, or people may feel like they're not getting the kind of service they're supposed to because the bartenders are hanging out with their coworkers instead. So really think about the way that you structure those rules. I'm not saying do away with the shift beer or whatever, but make sure that you're setting some pretty clear standards as far as what people are doing to avoid those kind of injuries and the negative reflection upon your business. So next, we'll deal more specifically about some of the management decisions as far as hiring and firing in your other management act. And that's to look at how discrimination occurs. And specifically, we're talking about unlawful forms of discrimination within the employment context. And so under federal law and state law, and sometimes even local laws, there are certain classes of people who are protected from discrimination in employment and other situations. These have all been around for a while. You've got sex or gender, race, ethnicity, national origin, age over 40, religion, if I didn't say that one. We now have some newer issues. Disability was added within, it's been around for a while too, really. Genetic information, not discriminating against people because they have some sort of genetic health condition. And of course, some newer issues are in the play as well with sexual orientation and transgender issues that there's some flex about where they fall within the law. Breweries run sort of a wide range of what I would consider a discrimination risk within the employment situation. On one end, we have many businesses which are owned by fairly conservative business owners who may have very specific ideas about the kind of people that work at their brewery, or their freedom from these kind of laws, all the way to breweries maybe situated in popular urban areas where they may be full of very liberal, open-minded type owners who take these things very seriously and have maybe more open minds about the people that they hire. And we've got everything in between. And if you feel offended by one or the other of those descriptions, it's worth pointing out that people who are conservative are not by default discriminatory or bad managers or owners or whatever. And the same is true of people who are liberal, are not always perfectly open-minded, and oftentimes can put their foot in their mouth or make bad decisions just as much as anyone else. And of course, craft brewing as a whole is an industry that's sort of steeped within white male culture. You go to breweries, you see people working there, the vast majority are white males. You go and look in the tap room, the vast majority of the people you see in there are white males. And so it is an industry that's been wrapped up within the assumption that white dudes are they're the workers, they're the customers. And if you really have any question about that, I would just point out the number of labels that are sexually suggestive about women and the number of beer names that are sexually suggestive about women, or the term for fairly light blonde beers as panty droppers. I mean, let's be honest here. There's not too much hiding about the focus of those beers and the craft brewing industry. And of course, a lot of that is changing, and there's a lot of movement away from it, but it doesn't change the fact that there's still lots of people working at breweries and owning breweries who lived through a time where craft brewing was more insular, and there were a lot fewer people beyond that white male market in both employees or customers. So the two areas of discrimination, I would say, really are at risk in the craft brewing are sex and age. And with the sex, we've kind of talked about this. There is that culture that's sort of dominated by white males. So you've got to be real careful that you're not making employment decisions that might avoid women from coming into those jobs, even if you feel like this is rough physical labor, cleaning mash tuns or whatever. It doesn't mean that women can't do that work, or that women should go into traditional women's kind of work as secretaries or office staff or these kind of things. Make sure that you're treating women as just effectively available and qualified to do any other job that a similarly qualified male candidate would. And as well, make sure that you're really keeping in mind some of that male culture that has been steeped within craft brewing, is not creeping into the workplace around women, and maybe exposing them to things that could be considered sexual harassment. And secondly, with age, there are certainly a lot of older people who are head brewers, who own breweries, who work at breweries in various capacity. With any kind of labor position like brewers are, there's always that heightened potential that employers will look at somebody who's an older worker and think, well, maybe they're not capable of lifting those grain bags or cleaning the mash tun or whatever, or they may have health problems that arise from these issues, and avoid hiring or promoting people who are older. And that's prima facie age discrimination. There are plenty of older people perfectly capable of doing that work. Lots of home brewers over the age of 40 who regularly are slinging around sacks of grain, cleaning mash tuns, obviously smaller, but nevertheless do that kind of work and are capable of doing it. So avoid those preconceptions that just because somebody is older, they're not capable of doing the job. Of course, if somebody is physically enabled to do the job, that may well be a very good reason not to hire them for a given position. And then the seventh issue kind of dovetails into the discrimination as well, and that's kind of the separate issue with ADA, Americans with Disabilities Act regulations. And of course, tied in with this is a prohibition on discriminating against people who are disabled. And that's very similar to the age. Just because somebody has a particular disability doesn't mean that they're unable to do certain kinds of work that's required for a given position. But keep in mind as well that there's a unique issue here with disabilities, and that's that people with disabilities are able to request a reasonable accommodation for the job, even to perform certain functions of the job. These reasonable accommodations based upon the size of your company and its assets may be not so reasonable to you, but reasonable under the law, to allow people with disabilities access to those jobs. So that can take a job that is somewhat physical in its requirements and require you to take certain steps, either with the equipment or premises of the work site and make some changes, or to reform some of the job responsibilities to make that job accessible to somebody who has a disability. Separate from the specific employment sections of the ADA as a whole has alternate regulatory sections that make certain requirements as far as making your business location accessible to people with physical disabilities, like wheelchair ramps and so forth. Make sure that you're keeping those in mind with the construction of the business, particularly with consumer available areas like restrooms and tap rooms, because those areas are also going to be available, of course, to the employees, and that may be part and parcel with accommodation issues that arise under the ADA. And these ADA reasonable accommodation issues can sometimes be very complex, and it's another issue where I would strongly encourage you to talk to your employment counsel or to talk to an attorney experienced with employment issues to get some guidance about what you should do and what you need to do. But generally, make sure that you are clearly defining job responsibilities and the requirements for those jobs. Don't make your job postings or your listing of job responsibilities, even for your internal documents, too vague. Make sure they actually specify what the job does. And there's some artistry to crafting those to make sure that they clearly identify to people what the responsibilities will be, and what kind of accommodations may be appropriate to that job. So as I said, this is really an issue where working with counsel is going to be worth the cost of getting that done, not just when an issue arises with an accommodation request, but ahead of time in crafting your definitions of job responsibilities and any kind of job postings you might do. So those are, as a whole, the 7 issues that I see arise the most within employment law in craft breweries. Down the road, we may see some of these issues change, or some of them become more prominent than others, especially as maybe OSHA investigators or DOL investigators come looking into some of the issues that we've discussed. And as the industry grows and more people are opening breweries and existing breweries are expanding and hiring new employees, then the possibility for these problems to arise becomes greater. Certainly, as a brewery increases its staffing, it can fall under additional rules or additional laws as far as what the employer can and can't do. For example, many of the discrimination laws require an employer to have 15 or more employees before those prohibitions on discrimination kick in. So as your staff increases, when you only have a couple employees, you may be able to get away with discriminating on the basis of age, but once you clear the threshold for that particular law, then at that point, you really got to be sensitive and make sure that you're following exactly what those rules say to avoid discriminating unlawfully. Same is true for FMLA, the new healthcare requirements. These all are keyed to the number of employees you have. But of course, wage issues, you only need one employee or one supposed employee for those laws to apply. So that's definitely not true of all of this. But these issues certainly will continue. It will grow with the growth of the industry. So it's important to keep those in mind. And if you've got some concerns, definitely to talk to qualified employment counsel. As always with these videos, they run incredibly long, and I feel like maybe I could cut some of this out, but I'll probably just leave it as is. So I appreciate if you made it through all 37 minutes of this, and I hope some of that information was useful. If you've got some questions or some feedback, feel free to leave those in the comments below. If you're looking for more information generally about some of these legal issues, especially with the wage issues and the discrimination, you can find some more information on my website, and the link for that will be in the text below the video. So I would invite you to take a look at that information as well, and beyond that, work with employment counsel to resolve these issues. So thanks again for listening, and I'll see you next video.